Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. This is going to be a brief short, I hope, on the power of judicial review. I want to start by saying that all interpretations expressed here are my own and are not to be ascribed to my school. I'm a professor of law at Mississippi College School of Law. But let's get right to it. This is a short on the power of judicial review. I hope you're going to want to learn more about it, and I'm giving you the links to the longer clips in the text box below. Now, we know that the national constitution creates three branches of federal government. We have the courts, we have the executive or the president, and we have Congress. Congress has the purse strings, so to speak, that appropriation bills originate in the House of Representatives and must move through the legislative process. We know that the president has the military. The president is the commander-in-chief of the military. And what does the court have other than the black robes, right? Well, in an older case called Marbury versus Madison that I talk more about in the longer clips I've linked below, in the older case, there was a conflict involving the new president, the newly sworn in president of the United States, and an attempt by a political party to control the courts before they went out of office. Oh yeah, I'm not talking about recent history. I'm talking about way back there. You better read about it, Marbury versus Madison. Well, in that case, the court did something very strategic. The court said, Mr. President, or maybe one day Ms. President, but Mr. President, we can tell you to deliver up the judicial commissions. We got the power. Someone must have the final say. But the court did something a little different. While articulating that the United States Constitution is of laws and not of men, while saying, Mr. President, we can tell you what to do, or we can tell you if what you did was constitutional or not, while we can tell you that, we're going to be somewhat delicate when we're dealing with our co-equal branches. So instead, the court restrained itself, and it did not give the mandamus order for the president to deliver up the commissions. Instead, it did something, I think, far more significant for the power of the court. The court said in that opinion, we have the power of judicial review in the final instance, so to speak, to determine if what others have done is constitutional or not. Oh, yes. Now, there are some limitations on the power of judicial review. Let me tell you briefly about one. Now, how do we get new federal judges and justices? You know, they do serve for life in good behavior, they say. They do serve for life. But how do they get there? The president appoints them with the advice and consent of the Senate. Now, as you might imagine, the president likely appoints those who the president believes ascribes to their views about various political and legal and constitutional power matters. But once they are appointed, even though the president appoints them with the advice and consent of the Senate, once they're appointed, They are indeed independent. Let me tell you about one. President Eisenhower appointed Earl Warren to be Chief Justice of the US Supreme Court way back during the times when, in Korematsu case, when Japanese American citizens were interned so that other people could feel safer, according to the court. Earl Warren had been a part of that internment process. But when Earl Warren, let me go back. So Eisenhower said, this is a law and order person I'm appointing to the court. But when Earl Warren became Chief Justice, Earl Warren led a court that has been considered to be the most liberal court or the most progressive court in constitutional history. His court brought in cases like Brown versus Board of Education 1 and 2, and Cooper versus Aaron, telling a governor to get out of the way and let the Black children enter into the formerly all-white public school. Now, President Eisenhower said, what's up with this? What's up with you, Earl Warren? I wanted a law and order person. Earl Warren said, I'm still law and order. I just believe in law and order and equality for everyone. President Eisenhower replied, and look, there's a curse word, but you know I'm not going to say that curse word on here. Well, they're kind of two cuss words, but I'm not going to say them. But President Eisenhower said, appointing Earl Warren was one of the biggest blankety mistakes I ever made. That's what President Eisenhower said. As for me, I had the opportunity to attend schools that were somewhat desegregated. Now, oh, it is so much more. You read about Earl Warren and President Eisenhower, you read about that. You read about the Constitution. And if you're just not ready to read, you watch those two clips that I've linked below to learn more about the power of the judiciary and all that they get done wearing those Black robes. Look, learning is so important. You see, I'm wearing my shirt. It says reading is my jail. You make learning your jail. You go and you take a soak in the law and not just a brief shower. I believe that learning will take us to enlightenment, and enlightenment to justice, or at least to a taste of justice. That's all for now. See you next time.